Testing appellant mic. Beautiful. Testing appellee mic. Check, check. Microphone 1. Microphone 2. Microphone 3. Check, check. Microphone 4. Microphone 5. Five again? All right. And mic check number 6.
Justice Lawrence sits back, so I was cracking way up.
Looks like 3 and 5.
Microphone 7.
anything to do before the Honorable Justices of the Supreme Judicial Court, sitting in the Law Court of Portland, within for the state of Maine, they go forth and declare, and they shall be heard.
Good morning. You can be seated. The matter before the court is Cumberland 2486, State of Maine versus Zackaria. I'm not sure what the pronunciation is. Okay. We are being streamed on the web, both by audio and by video. I see Counselor present. I'm assuming you're ready to proceed. And I would ask first, however, that you introduce yourselves by saying your names for the record, together with the party you represent.
Good morning, Your Honor. Michelle King for Saad, Zackaria.
Good morning. Grant Whalen for the state.
Thank you. And Attorney King, if you're ready to proceed, we'd be happy to hear your argument.
Good morning, and may it please the court. The Fourth Amendment provides protection from searches and seizures when there's a personal expectation of privacy that society is prepared to recognize as reasonable. In this case, a de novo review of the lower court's legal application in denying Mr. Zackaria's motion to suppress should yield a different result. In this case, the facts are largely undisputed, however, very important. Officer Bennis responded to a dispatch concerning an alleged assault and interviewed two women. One of the women was unable to give a description of her assailant. The second woman, however, described a black man with a green shirt carrying a backpack and a tablet. Based on this information and Officer Knight's knowledge that Mr. Zackaria was indeed black and had previously been seen carrying a backpack and a tablet, the officers responded to a local shelter. Once there, they were allowed in by staff, and they met Mr. Zackaria in a common area. They had conversation with him. At that time, they did not pat-frisk him. Rather, they allowed him to proceed back to a shower stall to collect his personal belongings. Mr. Zackaria walked into the shower stall and partially closed the door behind him, asking the officers to wait outside. From the outside, the officers could not identify the items that were on the floor of the shower stall. It was at that point that Officer Knight opened the door and ordered Mr. Zackaria out. Once Mr. Zackaria was outside the shower stall, the items on the inside on the floor were recognizable as potentially incriminating items. Mr. Zackaria had a personal expectation of privacy that society and courts across the country have recognized as reasonable. Although the issue of expectation of privacy in a bathroom stall has not been addressed by this court, it has been addressed by courts across the country. The overall conclusion is that a bathroom stall is private, at least to the extent that the doors shield the inside from view. In a case directly on point, the Hawaii Supreme Court and People v. Bigger determined that the defendant had an expectation of privacy in the bathroom stall, even though the stall door was only partially closed. Reasoning that the door did not close completely did not eliminate that expectation, since the crack was too small to afford the officer an occasional glimpse of the defendant or the person inside. Here, once Mr. Zackaria stepped into the sanctity of the shower stall and partially closed the door, he had a reasonable expectation of privacy in the items that could not be seen from the outside. The items were not in plain view until after his constitutional rights had been violated by Officer Knight opening the shower stall door and ordering Mr. Zackaria out. This court should reverse the lower court's decision and grant the motion to suppress. I'd be happy to take questions from the court.
As I understand the facts in this case, so it's Zackaria, not Zackaria?
Zackaria, Your Honor.
Okay, Mr. Zackaria, we had a debate about this. Mr. Zackaria was in the common area when the police arrived, is that right?
Correct.
And the shower stall was visible from where they were?
The shower stall was visible, but not the contents on the inside.
I understand that
Yes.
but the contents of his backpack or his belongings were on the floor?
Correct.
In the shower stall with an open door?
Correct.
While they were all in the common area?
Correct.
It's only then that he went back in the shower stall area and to start packing up his belongings, is that right?
Yes, Your Honor.
But isn't the fact that it was open and that he wasn't showering at that point? I mean, the door was open, the belongings were on the floor. Doesn't that undercut any reasonable expectation of privacy at that point? In other words, he's already, I understand they didn't go look at that point, but they could have. And isn't having the door open at that point already releasing, if you will, any reasonable expectation of privacy?
Well, perhaps, Your Honor, at that moment in time. But once Mr. Zackaria stepped into the stall, much like a person who might stand outside their home and then walk inside, the expectation flows from the fact that he then did walk inside the shower stall and close the door, albeit partially, behind him, and asked the officers to wait outside. It was at that point that his reasonable expectation required probable cause to have him step outside of that shower stall.
But he wasn't using the stall for showering. He had items strewn on the floor. So how is he having a reasonable expectation of privacy after he showered, just because the things are on the floor? He has no right to store things at this shelter, correct?
Well, actually, Your Honor, the courts across the country have talked about the space. And so in this case, the expectation of privacy derived from the space, not what Mr. Zackaria was doing inside the space. Once he partially closed the door, the items that were inside were shielded from the view on the outside, and his expectation of privacy flowed.
Well, they were only partially shielded, right?
I'm sorry?
They were only partially shielded. I mean, the door wasn't just a crack. It was open, what, about 12 inches?
It was about 12 inches, but the officers testified that they could not identify the items. So
But they could see that the items were on the floor.
absolutely, absolutely.
I noticed you strategically say he partially closed the door. Is that the same as left the door partially open?
I love that question, Your Honor. I'm a glass half full person.
Can I ask you, you said it's not what he's doing in there, it's the space, but let's change it. Suppose it's just a closet and the police come and he goes into the closet and shuts the door. Has he now created a reasonable expectation of privacy inside that closet?
Well, Your Honor, in most of the cases that talked about the expectation of a shower stall did liken it to the phone booth inside Katz. And so maybe it was a misstatement to say that it's, only the space and not what occurs in there.
It's
It
got
is
to be
twofold.
a combination, right?
Certainly, there are cases that talk about where two people are inside a shower stall, and the fact that the shower stall, the bathroom stall, is only meant for one person. There is an inference that what they're doing inside that bathroom stall is illegal.
So what do we take then from the fact here, as Justice Connors noted, that he was done showering, he was dressed, he was no longer using the shower stall to engage in what we would typically consider private activities, a shower. So doesn't that change the analysis?
Well, I would liken that analysis to someone who's in a bathroom stall and who has completed that task but is still standing in the bathroom stall. No cases talk about a reduced expectation of privacy just because the person hasn't opened the door yet.
Well, I may be going a little bit into the weeds here, but as I recall, he had gone into the shower area from the common room. And I think you suggested that they didn't pat him down when they arrived, but they then, as I recall, asked him to come out so they could conduct a search just to make sure he didn't have any sharp objects on him. Is that correct?
Yes, Your Honor.
So in this instance, he's exited the area that presumably he might have had an expectation of privacy when he went in, but he comes back out, leaves the door open, and they engage in the pat down. And at that point, they see the objects, have a fuller view of the objects on the floor. You weren't suggesting that there was something duplicitous going on by them not waiting to pat him down until after he'd gone in and then getting him to come back out, are you?
No, Your Honor. But my argument is that once he did step in there, once the officers allowed him to step back into that space where he had a personal expectation of privacy, they no longer could open the door and order him to come out without probable cause. The reasonable suspicion was no longer enough to accomplish that. And once they opened the door and ordered him out, the fact that the items were then able to be seen doesn't cut constitutional muster. And
So you're conceding there was reasonable suspicion when he went into the shower area?
there was reasonable suspicion, yes, Your Honor.
Your position is there was reasonable suspicion, but not probable cause at any point until they actually did the search.
Correct.
So is your view that they could have prevented him from going back into the shower stall? They could have
They
detained
could
him
have
as soon as...
patted him down, they could have had a conversation with him, and any of the officers could have walked over and seen the items on the floor. The door was open. At that point, they were in plain view. They were not in plain view when they allowed him to go back in and partially close the door, which created an expectation of privacy in my
They were in
client.
plain view before he did that.
They were. It wasn't noticed, but it certainly was plain view. If you look at the video, it's easily ascertained that the door was open, and had anybody walked over there, the items would have been in plain view.
Isn't the expectation of privacy contextual, meaning what's actually happening at the time? I mean, if there's a new house under construction that has a shower area, it's not complete, there's no water running there, and the police come and talk to somebody, they jump into the area, close the door, it's a shower stall, but there is no context. There's no shower going to take place, there's no bathroom function at all. Don't we have to look at the context? We don't look at the physical place that there's a shower stall right there. We look at the context that is occurring at the time when the right is claimed. Is that a fair statement?
Of course, Your Honor.
And in this context, other than the fact that it was a shower stall, there was nothing taking place contextually that would give him an expectation of privacy. Wasn't taking a shower, wasn't about to take a shower. It's just a place.
It was a place with a closed door where most people conduct private
Well,
things.
it wasn't closed, that's the thing.
I'm sorry?
It wasn't closed.
It was partially closed, and the officers couldn't observe the items that were inside. Well, rather, they could see them, they couldn't identify them.
But if the act, this follows up on Justice Lopez's question, if the act that makes it an expectation of privacy is not taking place, doesn't the space lose that status?
Well, again, Your Honor, I hate to beat a dead horse, but if a person is standing in a bathroom stall and they've completed their activities, they still have an expectation of privacy while they're stepping out. And in this case, Mr. Zackaria had indeed finished his shower. He went back to collect his personal belongings that were in a space that were personal to him at that moment in time.
Let me ask you this, you likened it to somebody, having the door open in their house and then closing the door. But let's assume the police are at somebody's house, the door is open, wide open, the person may be outside, right, the homeowner, and they can see inside something that may be contraband. The door's wide open. And then the person goes back inside, and maybe the door is now partially, closed, maybe 12 inches gap. Can the police go in and get what they saw was in plain view? They already saw it. The person had left the door wide open.
Well, what I would take objection to, Your Honor, is maybe they can see incriminating. That's not the standard. The standard is that the incriminating nature of the items have to be apparent. And in your scenario, and also in the facts of this case, the incriminating items, or the apparent incriminating nature of the items, was not seen until Officer Knight opened the door and ordered Mr. Zackaria to come outside. Had the officers been able to identify the incriminating nature of the items from the outside, it would be an entirely different
So
conversation.
if they move closer to the open door and now can see it, that's where you're saying essentially they messed up. If they had gone closer to see it before he went back in, then it wouldn't be a problem.
Well, I think where they messed up, Your Honor, is opening the door into Mr. Zackaria's space that he had an expectation of privacy in.
So we're talking about a public, there's no question that the common area was a public area, correct?
Correct.
The shower is right off that public area. That's a public shower, correct? It's
A
not
public
his.
shower that only at that time, due to COVID, certain people were allowed to use. Mr. Zackaria, there was testimony, and I think the lower court found that he was one of those people.
But if you change the scenario a bit, and we're talking about someone who's in a department store, they go into a changing room, the police first see items in the changing room, the person comes out, they talk to him, he goes back in and closes the curtain a little bit. I mean, the police know that there's something in there. It's a public area. I don't understand where the expectation of privacy arises here.
Well, in your hypothetical, Your Honor, I think there would be an expectation of privacy in the dressing room as well, unless, again, the incriminating nature of the items were viewed from a place where they were supposed to be. In this case, there was no there was nothing to suggest that the police could see any incriminating nature of any of the items.
So what you're saying is, if you use a shower stall and you shower and you then get dressed and you leave your items strewn on the floor and you walk out and you leave the door open, that somehow you have retained an expectation of privacy in the items that you left strewn on the floor?
When you walk back in and close the door, yes, Your Honor.
And how was that retained? When he walked back in, he's not using it as a shower stall. He has already left the items there. He's already fully dressed. And he's an invitee. It's a day shelter. I'm not seeing where he would have an expectation of privacy. Why would he think that's protected?
It's the retained that I hate to use the word objectionable, but it's a new expectation of privacy when he walks in and partially closes the door. While he was standing in the common area and the door was open, certainly he had no expectation of privacy. It was in plain view. Mr. Zackaria walked in, closed the door partially behind him. It was at that point, when the officers could not see the incriminating items on the floor, that he had an expectation of privacy to his personal belongings in a personal space.
Thank you, counsel.
Thank you.
Attorney Whelan.
Thank you. Excuse me. Good morning, Justices and Chief Justice Stanfill, and may it please the Court. The lower court did not err in this matter by denying Mr. Zackaria's motion to suppress evidence gathered from a day-use resource center in which he did not have a reasonable expectation of privacy akin to a residence. Short of being a homeless shelter for overnight stays, this facility is only ever designed for day use. Nor did the court err when it ruled that the evidence seized from an open public shower stall was lawfully obtained. Lastly, the court did not err when it denied Mr. Zackaria's motion to dismiss on the grounds of a speedy trial violation, given the various reasons for the delay in this matter. I would invite questions at this time.
Well, let me ask you first, do you agree that at the point at which the officers go in, ask him out, and search for his belongings, that there was not probable cause and that there was only a reasonable articulable suspicion?
Yes, Your Honor, I would agree at that point.
And let's talk then about, do you agree there would be a reasonable expectation of privacy, for example, in a public bathroom stall while someone is using it for the purpose for which it is intended and the door is closed?
Yes, Your Honor, and I think courts, obviously we haven't addressed that here in Maine, but the courts that counsel cited to, and cases that counsel cited to, and other cases all recognize that for the purposes of using the restroom, there is a reasonable expectation of privacy in that stall. That's obviously subject to specific jurisdictional limitations. Some courts have said that officers could observe between the doors and what they
but
can't.
you agree that there's a reasonable expectation of privacy at that
With a
point.
closed door, absolutely, Your Honor.
And if somebody is using a shower, whether it's a public or semi-public shower, but something other than in their home, if the door or curtain is closed and they are using it for the purpose for which it's intended, you would agree that there's a reasonable expectation of privacy?
I would agree with a closed curtain and a closed door. Even a public shower does garner a reasonable expectation of privacy, yes, Your Honor.
Yeah.
I think the other case law bears that out as well.
So at what point did Mr. Zackaria lose that reasonable expectation of privacy?
Well, it's important to remember the facts here where officers arrived, and of course, Officer Knight had a relationship with Mr. Zackaria. Mr. Zackaria had come.
Well, he knew who he was. I mean,
well,
I'm not sure you'd call that a relationship.
Well, Mr. Zackaria had come to Officer Knight multiple times with the tablet, expressing concern over people following him, which is why when the description went out over the radio of a tall black male with spiky hair who was carrying around a tablet, Officer Knight immediately thought of Mr. Zackaria, and that's when officers tried to determine his location, found him in the renovating Preble Street Resource Center. So at that point, when they walk in, Officer Knight sees Mr. Zackaria out of the shower stall across the common area at a sink. The door to the shower stall at this point is open. And the staff that are working there, the very staff that invited both the officers and Mr. Zackaria in,
So is
are
it
also
your
there.
position that he lost that reasonable expectation of privacy once he exited the shower stall?
Once he was no longer using the shower stall for the purpose of showering and opened the door, he would once his items and the contents of the shower stall were exposed to the public in that public space, at that point he no longer has a reasonable expectation of privacy.
So I think it's Attorney King's position that, but then when he re-entered the stall and at least partially closed the door, left the door partially open or partially closed it, I'm not sure.
I prefer the terminology left partially open.
Why am I not surprised? That he essentially regained that expectation of privacy because this is a space. And, essentially, one could argue that, collecting my belongings is still connected to the act of showering.
Absolutely, Your Honor. And Justice McKeon, who decided the lower court suppression, indicated in his opinion that had the door been closed, there may have been just such a reassertion of a reasonable expectation of privacy.
So
However,
does it
the
turn
door
on the
never
fact that
closed.
he didn't close the door, that simple?
I don't think it's that simple. I would also factor in the fact that, when he returns to his items, which are strewn about the floor, they're not still contained in a bag, but they're strewn about the floor. When he returns to the shower stall, he's not there for the purposes of the shower stall. He's there to gather his items. And so he's no longer using the stall for its intended purpose, much like the hypothetical individual who's not using the bathroom stall for the purposes of the bathroom. Attorney King's example of how when you finish using the restroom and you stand up, you still have the reasonable expectation of privacy, I would agree with. And you have that expectation of privacy until the door to the stall opens. If you then leave the stall and come back in and have no intention of using the bathroom again, you don't have as much reasonable expectation of privacy. Again, it is that fact-specific nature of the use that the courts have always
It's the
looked
use
at.
and the type of space combined.
Exactly. And this was obviously a very public space, had no intention of overnight dwelling, simply only used for the purposes of showering.
If the officers had gone directly into the shower stall before even talking with Mr. Zackaria, would they have been lawfully able to take those items out of the shower stall? They were in plain view at that point.
They were. Had they arrived on scene, seen Mr. Zackaria across the common area, and seen an open shower door with his belongings in it, and had walked straight over and looked at those items, that would have been lawful.
I mean, that is what happened except they didn't walk over, right?
They decided to make contact with Mr.
Right.
Zackaria before looking into the shower stall.
So my question is, can an individual now recover what was once in plain view and could have been accessed by law enforcement? Can someone now shield that by throwing a blanket over it or closing a door?
I think, as Justice McKeon stated, if he had returned to the shower stall and closed the door, there would be an assertion of some form of reasonable expectation of privacy. Whether or not it's enough.
What if he threw a blanket over it?
I think that would also, on an evidentiary evaluation, factor into probable cause if he was trying to conceal evidence. So I think taking that hypothetical to, I'm not sure that we have the facts here to answer that question, but yeah. So I think that there's an element of trying to conceal evidence at that point that officers would factor into their determination of whether or not they had probable cause.
Is that what he was? Well, we don't know. The record doesn't say one way or the other what Mr. Zackaria's motivation was at that point.
Well,
I
you're
would not-
saying
I would
either
not-
way. If he had left the door open, he has no expectation of privacy, and you're saying if he had closed the door, then he would have been concealing something, and that would be probable cause. So he's, either way, you think you've got him, right?
I apologize, Your Honor. I'm not saying if he concealed, we automatically had probable cause, just that it would be a different factual determination.
We sometimes ask advocates what they think a ruling should be when it's a case of first impression. It sounds to me like you're saying that there are two factors here. One is the space itself, shower space, bathroom space, and that the second element would be use, what I was calling context earlier. And it sounds like you're saying if you have the space, which is ordinarily a private space, but it must be used for the purpose of the space itself, And if that element is missing, the actual use, then there is no reasonable expectation of privacy. Am I correct so far in where you're headed with it?
I think so, Your Honor. You don't have a reasonable expectation of privacy to use a public space that has a specific purpose for a different purpose.
Okay. So if in fact the person is in a space that's ordinarily used for private purpose, and they're no longer using it for that purpose, perhaps getting ready to exit, do they still have the reasonable expectation of privacy at that point?
I think the reasonable expectation of privacy would attach up until the point where the space no longer became semi-private, when the door opened.
Okay, so the tipping point for you then is when you have the space, you have the use is completed, and the sealing process is no longer sealed.
I would phrase it a bit of a different way, Your Honor, but I think you are correct. When a public place has a semi-private use, and that private use is completed, and then there's an abdication of privacy. Because the reasonable expectation of privacy that we talk about in a hotel room or a home is obviously vastly different than in a public shower stall.
The reason I'm trying to get specific on this is because if we issue a holding, people want to say, okay, when does that reasonable expectation of privacy stop? Is there a magic moment? Is it left to the individual facts of the case?
I would go back to what Your Honor, apologies. I would go back to what Your Honor was talking about, the context of the space. Whatever context that space affords for the use of privacy, whether it's the drawing of a curtain, closing of a door, whatever, whenever that space is disengaged, whenever that mechanism is disengaged, then you would no longer have the reasonable expectation of privacy.
Well, here, according to how it's been argued, it's not a question of when it was lost. It's a question of whether the expectation of privacy was regained by his walking back into the shower stall fully dressed, not using it as a shower to pick up his items, and he only partially closed the door. So he's already completed those uses, so why would he regain, if he lost the expectation, what is it that he would have to do to regain, or could he ever regain unless he started using it again for showering purposes?
I think in answer to Justice Mead's question, Justice Connors, that's exactly what I would say, is if he wanted to regain a reasonable expectation of privacy in a public shower stall, he would need to close the door to initiate the private nature of the expectation and then use that space for that purpose.
So in other words, if when the officers had arrived, let's say he had completed showering, his belongings were, strewn on the floor in the shower area, and he's out in the common area, but only partially dressed or with a towel wrapped around him. And then he goes back into the shower area to complete dressing.
And he closes the door.
Well, let's assume it's 12 inches. It's closed enough so that they can't see him dressing.
I think in a public space with a public shower stall, if the door is left ajar, then Mr. Zackaria is sacrificing his reasonable expectation.
Even though he's finishing up what he was doing, essentially.
I think both elements have to be there. The context needs to be used, the space needs to be used for its intended purpose, and there needs to be an affirmative mechanism that the person who's using this private area in a public space is asserting the privateness of their action, and it's being for the proper purpose. I think both need to be present.
And we keep referring to, glass half empty, half full. We keep referring to this as a shower stall. This is a shower room area in which there is a shower stall. He's never in the shower stall that's within that room.
He is fully dressed when officers arrive.
He's fully dressed, and he's picking up his personal belongings at that point without closing the door behind him.
Yes, and he's fully dressed in the exact outfit that the description from both assailants indicate that he was dressed in. Green mossy shirt and spiky hair.
So your view is, under the particular facts here, he really couldn't have regained that expectation of privacy. Is that right? I mean, presumably the police weren't going to let him go shut the door and take another shower under the circumstances.
I don't think Officer Knight or Officer Bennis were going to do that. The conversation that came in through testimony at the motion to suppress was that after Officer Knight engaged with Mr. Zackaria, because of their previous talks about his concerns about surveillance, that very shortly after Officer Knight began his conversation, Officer Bennis indicated that we're investigating a stabbing, we need to pat him down. And so I don't believe he would have been able to go back into the stall and shower again.
So in this case, whether the door is partially open, partially closed, doesn't really matter in your view. He's abandoned any reasonable expectation of privacy by the very nature of being done showering, dressed, left the door wide open, and there's really nothing he could do under these circumstances to regain it. Is that a fair?
I think so, Your Honor. From the state's perspective, he's abandoned all expectation of privacy when he left the shower stall with the door open, and at that point, officers arrived. At that point, he doesn't have a reasonable expectation of privacy. It's a public space.
At what point do you think probable cause was established?
Once officers saw the nature of the weapons that were strewn about the floor. Officer Bennis was the one who interviewed the first victim and saw the nature of her injury. And then when he leaned over after Mr. Zackaria had exited the shower stall, when he leaned over and looked down, he could immediately see that the objects Mr. Zackaria had could very easily have been used for that injury.
Well, to the extent that there was a description of the individual, clothes he was wearing, type of hairstyle, and certain objects that he had with him, you don't think that probable cause was established that he may have been the person who committed the offenses in question before finding the objects?
I think that, yes, Your Honor. I think probable cause could have been established. Actually, Your Honor, Chief Justice Stanfield asked if I had, at the beginning of my time, if I thought reasonable articulable suspicion was established at that time. So I'm going to stand by that. I think officers were in the process of developing probable cause. You can change your mind if you want.
I know she's Chief Justice, but you have free will here.
I appreciate that, Your Honor, but I'm going to stick
I get
to
no
my
respect.
Any last questions? I'm running out of time.
Well, you have 20 seconds about speedy trial.
A review of the docket record here indicates that there was a significant amount of time spent in mental health court establishing Mr. Zackaria's competency. I would also point the court toward Drury, the case that I mentioned in my brief. The facts of that case are almost exact to the procedural posture of this case, except for here we have the added factors of restoring competency, a severe accident, a car accident which caused a change in counsel, and also the impaneling of a jury that ultimately was deemed deficient. So take those three factors, add them all to the factors that this court identified in Drury as being not sufficient to grant a motion to suppress, and I would ask the court to deny that as well.
Thank you.
Thank you.
Attorney King, do you agree that because there was a choice, the officers decided to engage with Mr. Zackaria first when they got there as opposed to going to the stall? So do you agree, though, that they really didn't have a need, given that, to check his belongings for safety purposes until he went back to the stall and had access to them?
Well, Your Honor, I would suggest that they certainly could have.
They could have, but they didn't have, the need, as long as they were engaging him separately from where his belongings were, it was only once he went back to those belongings that became more important to see what was in the belongings.
Certainly, while they were engaging him in discussion there, they had no reasonable, fear for their safety. But they allowed him to walk back there. So at any point as he was walking back there, they realized that he was going back to the room where his items were potentially left. And they allowed him to do that. They could have pat-frisked him at any point along the line, but they didn't. They allowed him to go back, partially close the door, which again created an expectation of privacy, and then violated his privacy rights by opening the door and ordering him out. There are no further questions?
There don't appear to be.
Thank you.
Thank you, counsel. As is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. It is also our custom, however, to ask a first-time arguer, Mr. Whelan, I understand this is your first time appearing in front of this court, to ask counsel to come back and take the greetings of the court. We'd be happy to meet with you.
All rise.
Good morning, you can be seated.
Creature of habit. Creature of habit.
The matter before the court is Knox 24-538, Rachel Klotz versus J100X LLC. I see that counsel are present. I'm assuming you're ready to proceed. If you could identify yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Good morning. Tyler Smith for appellant J100X LLC.
And Asha Zackaria for appellee Rachel Klotz.
Thank you. And Attorney Smith, if you're ready to proceed, we'd be happy to hear your argument.
Thank you. Good morning, and may it please the court. This appeal turns on the evidentiary burden required to justify prejudgment attachment. The Superior Court here entered a $3 million attachment against J100 LLC, an entity that is barely mentioned in the record, and without evidence that Ms. Klotz is more likely than not to recover a judgment against that entity, much less in the amount that was specified in the attachment order. Ms. Klotz's affidavit attributes practically every wrongful act to Mr. Haley personally. It does not identify a single transfer or a single transaction involving J100X LLC. Now, to excuse these deficiencies, Ms. Klotz argues that the nature of her claims would make it difficult for her to make those factual assertions early in the case, and perhaps so. But a prejudgment attachment is just a provisional remedy. And like any other litigant, Ms. Klotz has a right to pursue discovery, and she can even seek an attachment later in the case. Nothing in Rule 4A or Rule 4B suggests that a different standard applies in cases like this where the party seeking the attachment claims that it would be difficult for them to meet the standard. At bottom, what Ms. Klotz's argument does is suggest to the court that it should retreat to the former reasonable likelihood of success standard that existed under the rules in 1992 before the rule was amended to require the proponent to show that they are more likely than not to recover a judgment and also to substantiate the amount of the attachment to that same standard. I'm happy to take any questions from the court.
If we believe that an attachment was justified, but perhaps not in the amount in which it was granted, but would be, say, justified in 1.7 million, can we simply modify the amount of the attachment?
I believe the court has that authority, that if you find that Ms. Klotz had justified the attachment to a certain amount, that it could be vacated in part.
Yeah, it would be a bit of a Pyrrhic victory for you. But.
That's one distinct possibility, Your Honor.
Who are the members of J100X? Is Mr. Haley the sole member, or is Ms. Klotz also a member of that LLC?
Mr. Haley is the sole member, Your Honor.
Because she alleges in her, or states in her affidavit, that he and I are the only members, and they, including J100X LLC. And does that change in any way if that's true, does that change in any way the issues before us today?
If there were evidence that she was in fact a member?
Yes.
I don't believe that changes anything, because that doesn't establish the elements of the various torts and causes of action. I think it's a relevant factor, but there are still other parts of the case that would have to be established. She would have to establish that her membership involved one of these wrongful transactions that she's alleged. She'd have to establish the amount of it.
Let me ask you this, though. Would you agree that as to Mr. Haley, a claim was stated sufficient to affirm, if you will, the attachment as to him?
I need to caveat that I do not represent Mr. Haley, and he's separately represented, but from my perspective as J100X LLC's attorney, we don't have any basis to challenge the determinations as to Mr. Haley that were made.
Then can't all of the assets of J100 be attached in the attachment against Mr. Haley, where he's the 100% owner?
No, Your Honor, because they're separate litigants, they're separate entities under well-established public policy concerning the separate identity of limited liability companies.
Well, I understand they're separate litigants, but what I'm saying is if an attachment, including attachment on trustee process, lies against Mr. Haley as the 100% owner of J100, wouldn't that be part of the attachment? Wouldn't you have to give a trustee disclosure in that respect?
No, Your Honor, I believe it would be conceivable that his membership interest in J100X LLC, perhaps that, but I think even that is a stretch where you have a separate existence by the LLC itself. I mean, there are certainly procedures that can be used post-judgment to attach a membership interest, but that doesn't mean in the pre-judgment attachment context that all of the assets of J100X LLC are in effect Mr. Haley's assets. And that goes to the issue
He's the sole member.
Of an
They
LLC?
are,
Yeah.
aren't they? Who else would have a claim to those assets?
Well, Your Honor, it's a separate LLC. It could be creditors of the LLC, and that's why this is important, that the LLC is treated differently. So say, for example, that an LLC has creditors. They, in addition to the owner of that LLC, even if it's a single member, would have a claim to the assets, and that is why these separate...
It's an inchoate claim. It's not a current claim, at least on this record.
No, and I agree, and I understood the question to be more or less in the abstract. When you have a single-member LLC, does that mean that all of the LLC's assets are automatically the assets of the owner? And that's simply not the case.
Ultimately, they may not be, but presumptively they are, aren't they?
That's one possibility.
Well, it's a pretty good possibility, isn't it?
In many cases, it will be, but there's nothing in this record establishing that any assets that are owned by J100X LLC are, in fact, Mr. Haley's assets. And
Other
again,
than his own statement that he's the 100% owner.
excuse,
Other than his own statement and disclosure that he's the 100% owner.
no, that's true, but I'm unaware of any case in Maine or really elsewhere that says that a single-member LLC, that all of their assets are automatically the assets of the owner.
Well, but
such
it's
that
not
they can be
automatically. It's a
attached.
question of the attachment. In other words, as part of the attachment, including attachment on trustee process against Mr. Haley, you don't think that whatever J100 is affected by that?
Well, I think it could be affected to the extent that, let's say, for example, that Mr. Haley were to try to transfer his membership in J100X LLC to another party. That could arguably be prevented by an attachment order.
So you're
But
saying
that doesn't
only the
mean-
shares and not any of the assets would be affected by the attachment?
Right, and those are two separate issues. And again, it's for the reason that I discussed earlier, where just because he's the sole member, that does not mean that he is the sole interested party. And that could be the case with really any LLC. And that's the whole problem with the reverse
Do you think that
piercing issue.
J100 would at least have to disclose what assets there were and the other things, as in, a trustee return?
I think is your question in reference to if a trustee summons was served on
Correct.
J100X. Certainly, if it received a trustee summons, it could be required to disclose assets that it's holding on behalf of a third party, such as Mr. Haley or anybody else who has a trustee summons in their favor.
Is the tipping point here the fact that the line between Haley and the LLC and where the money went is not clear from the affidavit? I mean, in this case, it's by affidavits, and Haley's affidavit doesn't really tell us anything, but the one filed by the plaintiff here was very extensive and includes admissions that Haley had made about the terrible things he'd done. But what seems to be a little fuzzier is whether or not the money went through Haley and into the LLC. At best, the affidavit seems to suggest that, where else has it gone? We can't track it anywhere. Is that the tipping point on this, that we cannot connect the LLC with the movement of the money that Haley obviously did?
I think that's the central problem with the attachment is to J100X LLC is there's no evidence that actually ties any of the funds, the short-term loan, the various investments over multiple years in unspecified amounts, that none of those transactions are linked as a matter of evidence in any way whatsoever to J100X LLC. And that's...
The affidavit does say in general terms that, yes, I gave him this money, he was going to invest it for me, and he created LLCs for the purpose of investment. From that, can't the court infer, okay, well, he's basically made an admission that these are the places where the money was going to go, and if we draw that inference, then yes, there is a significant likelihood of a success on the merits.
Possibly under the old standard of reasonable likelihood of success, where there could be some element of conjecture included, but when the rule was changed in 1992, it required an evidentiary finding of preponderance by the evidence. So a good way to actually look at this is analytically is to imagine this wasn't a prejudgment attachment. Imagine it was a motion for summary judgment.
Well, there was a motion to dismiss filed, and that was denied, which means that the question of whether these claims are legally sufficient has been decided and is the law of the case. So are you arguing basically an evidentiary, this is an evidentiary determination? And is the court, even the trial court at this point, in a position to make that judgment, given the nature of the claim here, which is a reverse piercing claim? This is really a claim against Mr. Haley and alleging he's playing a corporate shell game, essentially. That's a pretty complicated set of facts. Is that something that the court should be deciding on a motion for attachment?
I don't believe so, and I would agree that this is really an evidentiary question, and of course, the pleading standard under Rule 8 is different than the standard under Rule 4, where you have fair notice pleading.
Well, let me ask you a question, though, switching gears a little bit. Under the rules on a motion to dissolve, the court is required to have a hearing only to the extent and the plaintiff only has to burden any finding that the moving party has challenged by affidavit. Essentially, all the affidavit from Mr. Haley says is, J100 was not involved. It says nothing about the amount. It doesn't have any details. It just says J100 wasn't involved. Is that sufficient to require a hearing on a motion to dissolve or any other justification? And if not, isn't the judge in that sense, justified in simply keeping it in place?
It is sufficient for a couple of reasons. The first being is that the only thing that needs to be attacked in the affidavit is the findings in the ex parte order. The ex parte order had no findings other than to simply say that the standard was met. And then additionally, this is essentially to prove a negative, and what more is there for J100X LLC to say beyond Mr. Haley's the sole 100% member, and that J100X LLC was not involved in the transactions or the transfers alleged in the complaint.
Thank you.
Thank you.
Attorney Zackaria, did I get that right?
Yes, you did.
Okay.
Thank you, Your Honor. The date and 2 words and a signature, and that is all that is before the court. The appellant never filed a Rule 52B motion. Therefore, if under any interpretation of the filings in support of the motion for attachment, it was not an abuse of discretion for the trial court to have ordered the attachment, then this court must infer that the trial court made those factual findings and those inferences necessary to support its ultimate conclusion to grant the attachment against J100X. The direct way for the trial court to have made this conclusion is that Ms. Klotz established that it is more likely than not that her direct claims for fraud and conversion will be successful against J100X. But if the court cannot find any means to support all those direct claims, then to supplement, this court should infer that the trial court made all factual inferences necessary to find that J100X was created as the alter ego of Mr. Haley to defraud Ms. Klotz. And so to avoid injustice, the trial court disregarded the corporate form under Maine's well-established alter ego theory of corporate veil piercing. So Though ordinarily that law is used as a result that a shareholder is liable for the actions of the corporation, this is a set of facts that will establish that alter ego veil piercing under Maine's law goes both directions. And this has long been recognized in other states, New York since at least 2000, and California since the 1950s. As I said, this is the ordinary result, is that a corporate shareholder is responsible for the doings of the corporation, but that is actually the result of the application of the law, and it's the relief sought. But alter ego veil piercing is actually the relief that is actually given is a disregard of the corporate entity to avoid injustice. So here, Ms. Klotz has asked the court to apply the facts to the existing law as it is under Maine, that the corporate entity in this case should be disregarded to avoid the injustice allowing J100X assets to be squandered during the pendency of this action by Mr. Haley. So I will yield my time.
So, counsel, the issue here really is not whether it was okay to issue the original attachment and attachment on trustee process order. The issue is whether it ought to have been dissolved. Do you agree upon the motion?
Yes, and that is the two words of motion denied that is before the court.
Correct, but doesn't the rules, Rule 4AJ and Rule 4H, both indicate that in the event there is a motion to dissolve supported by affidavit, quote, "The court shall proceed to hear and determine such motion as expeditiously as the ends of justice require. At such hearing, the plaintiff shall have the burden of justifying any finding in the ex parte order that the party has challenged by affidavit." The affidavit is sparse, but it does say, no, I didn't, J100 was not involved. There was no hearing held in this case. I mean, isn't that a problem right there? I mean, the judge denied it without comment a year and a half later, which is a little odd, but also no hearing was held.
Your Honor, that issue of whether a hearing was appropriate or necessary, it was actually not raised as a basis for this appeal and has not been challenged. So we would say that to the extent that it is any issue, it has been waived.
Well, one thing a hearing might have probed would have been the amount of the attachment requested. The law requires there be specific facts to support the amount, and it's your client's burden to establish those facts. I understand the Rule 52 point that you're making, but putting that aside, as I look at this record, I have a hard time getting from basically 1.6 to 3 million. Can you address that, please?
Yes, Your Honor. So I'll put aside the 1.6 and another 70,000, which was the earnings that were lost on the Vanguard account for this transfer. The remainder, 1.33 million, would relate either to punitive damages or other damages that the Ms. Klotz would be entitled to. This is an egregious record. It's not only the fraud.
But there's nothing in the record to justify that specific amount. I mean, that's a big number. It's not like, oh, add in a few dollars more for, distress and for punitive damages. You added in $1.3 million.
I understand. Your Honor, we do, to rely again on the Rule 52B is, the question is there inferences? And the court can make reasonable inferences and projections.
Except it really is your burden to establish the amount.
Yes, Your Honor.
And just saying, I think it's this much, is that sufficient to establish the amount?
I think what we actually did to defend it is to lay out the egregious nature and that punitive damage would be appropriate. I would just again point out, it's not only the fact that Mr. Haley stole or converted Ms. Klotz's assets, he also involved her in the fraud against the federal government by listing her as an employee. There are damages that run the gamut, even to the point of Ms. Klotz being potentially investigated as part of that action, those PPP fraud issues.
But there's no quantification. There's no quantification, even with respect to the egregious conduct that you referred to. No quantification of how that would translate into punitive damages. So isn't that problematic?
I think that under the rules of Rule 52B and then also the abusive discretion standard, the trial court can make a reasonable projection of what it considers to be appropriate damages. And there have been damages in the amount of $1 million, even in financial cases, including Chinquette versus Chinquette, which was $1 million damage that was granted to the plaintiff in that case.
Yeah, the key word, though, is reasonable inference. I mean, based on the record facts that we have, is it reasonable to infer that there would be another $1 million+ damages here? I mean, we have case law that says that an informed projection can be made, but I think that still needs to be based on specific facts. You have to infer from facts. That's still quite a leap, going from 1.7, let's say, to 3.
It's 1.3. I agree, but even Chinquette was a significant amount of time ago. And
in the Bowman case, it was a personal injury claim, $6,000 in medicals, and the plaintiff was claiming $250,000 in mental anguish and lost earning capacity, and we set that up. The court attached, there was an attachment placed for $100,000, and I believe we even vacated that because on the grounds that there was not sufficient specific facts. And that was under the earlier relaxed standard that Mr. Smith is referring to.
I mean, Your Honor, I go back to the issue of it. It was either a reasonable extension that the trial court made and is supported by the affidavits, but in the alternative, the court, I agree with my counsel that you can modify, vacate to the extent of the amount.
In your client's extensive affidavit, it simply, but clearly, paints up and establishes the wrongdoing by Mr. Haley, who basically admitted taking the money fraudulently. That's made out in spades, but the attachment here runs against the LLC, obviously. So what I take from the affidavit is, yes, this person misrepresented, defrauded, he did this, and he took a lot of money, and he spent a lot of it and made a lot of LLCs. But your client, I guess no one in your camp knows where the money actually went, or at least the affidavit doesn't disclose that connection there. Can you address for me that disconnect there? In other words, we have to somehow loop in the LLC here before we can attach it to assets.
Right, absolutely, Your Honor. The issue here is, right, we're looking at the affidavit as a whole, and if we look at the allegations, they are, Mr. Haley did not have adequate assets. He did not pay for the car, he did not pay for the mortgage. Ms. Klotz provided him funds for the purpose of investments. She expected repayment, she expected dividends. He created 15 LLCs for the purposes of these investments. He claimed, and he was the sole member, especially of J100X. And the affidavits do show the money moving around, using Justice Douglas's term, in a shell game. That was what he was doing. And as you pointed out, Justice Mead, she could not track it only so far. So the question for the trial court was, isn't it more likely than not that all 15 entities that Mr. Haley created for the purpose he claimed of handling Ms. Klotz's money were involved in the shell game that he was playing?
That's where the money went? So,
that's where...
So the court can infer from those facts that this LLC and others are the place where the money eventually arrived, and that's why it's being attached.
Yes, that is more likely than an allegation that 14 of the entities were involved in the fraud, but J100X was somehow remained legitimate. That is more unlikely than the fact that all 15 were involved. I will just note one point on the affidavit provided by Mr. Haley. It indicates the fact that J100X was not involved in the transactions as set forth in the complaint. As we noted, the complaint is a notice pleading standard. Right. It does not address the issues of, did the money ever, there are a lot of assertions that could have been made in that affidavit. J100X never held any of Ms. Klotz's funds. None of the money ran through that account. We never use, or J100X never used any of Ms. Klotz's funds for any illegitimate purpose.
So is it your view that that affidavit is insufficient to support a motion to dissolve that would require a hearing?
Yes. If anything, even that second allegation doesn't address the affidavit of Ms. Klotz. It only actually addresses the complaint.
I think the opposition acknowledges it much. I mean, their attack is on the four corners of the affidavit itself, saying, where's the connection, where's the nexus? And I think your argument, correct me if I'm wrong, is that it can be inferred from the facts in the affidavit. So if we agree with that, then you're on solid ground. If we say, that's too big of an inferential jump, then that throws it back into the challenge to the four corners of the affidavit.
Well, I would only point out, Justice Mead, it would be that the trial court inferred it.
Right.
And the question for you is, it wasn't an abuse of discretion for the trial court to infer it.
Yeah, correct.
I will make one further point, and I'm happy to take any further questions, but my last point would be is, if the court, there is a public policy issue that is now before the court. If the court doesn't recognize the actions of Mr. Haley running a shell game and hiding assets in multiple LLCs for the purpose of defrauding his victims, if the court doesn't recognize that alter ego reverse piercing here, the next defendant is going to create 20 LLCs or 25 LLCs to hide these assets from their victims and be able to continue to utilize those assets during the pendency of any action.
Well, that question's not before us directly today, right? We're talking about an attachment today.
Yes, but the recognizing that reverse piercing would support the finding of an attachment at this point, that's what we would argue is before the court today. Thank you.
Thank you. Attorney Smith, I'm going to pick up on a question that I ask opposing counsel, which is, in this case, you didn't appeal from the grant of the attachments. What you appealed from was the denial of the motion to dissolve. Do you agree that if the motion to dissolve and the affidavit supporting it is insufficient to require a hearing, then it's really game over?
I, of course, disagree with that.
Yeah, I know, but tell me why.
If the court were to conclude that the affidavit was insufficient to trigger a hearing on the motion to dissolve, I would agree. However,
I know you don't concede that it is insufficient. I just, but you agree that it's really kind of too late to attack the original grant of the motion. You can only do it through the motion to dissolve.
I agree that the rule requires that the attachment be challenged by affidavit. But if you look analytically, the burden here is ultimately on the party seeking the attachment.
But on the motion to dissolve, the burden is only on that party to justify what is challenged by affidavit. And if the affidavit is insufficient, there's nothing they have to do at that point.
Well, in the case where an attachment is granted, shouldn't the party who is subject to the attachment be able to have an opportunity to come to the court and say, this affidavit...
Let me refocus the question. Why is the affidavit here sufficient?
Mr.
Mr. Haley's affidavit, why should we consider it to be sufficient?
Well, two reasons. One is that the rule requires that the affidavit, that any findings in the ex parte order be challenged by affidavit. And my question would be, what findings in the ex parte order? There are none. All it says is that Ms. Klotz is more likely than not to recover judgment.
Opposing counsel brought up the point that there was no request for findings on that, and in that event, without a Rule 52 motion, we make we give any reasonable inference credit, don't we?
Well, it was an ex parte order that was issued before J100X was even served.
Which is why you have the opportunity to challenge it.
Exactly. So we had the opportunity to challenge it. We did that. The court disagreed. Now, I agree that as far as the ruling on the motion to dissolve, this court standard of review is that you would infer any facts that are reasonably supported in favor of Ms. Klotz as the prevailing party below. But I don't think that says anything about the sufficiency or insufficiency of Mr. Haley's affidavit to trigger the process for a motion to dissolve. And I would add, too, if
Point is, once he challenges it, it's an open season on the affidavit itself to get the attachment in the first place.
I think that's consistent with your more recent holding in Portland Museum of Art versus Germain, where you talk about once there's a motion to dissolve, it's treated as a contested motion for attachment.
But so what you're suggesting is that an affidavit sufficient to trigger that contested hearing is, in any case, is simply, basically, I deny the allegations, or I deny what she said in an affidavit, and that's sufficient.
It's certainly enough in this case where there are no specific findings, and I also believe challenge by affidavit could include pointing out that the initial affidavit is itself insufficient to establish the attachment.
Thank you.
Thank you.
Thank you, counsel. As is our usual practice, we will be taking this matter under advisement and issuing a written decision in due course. And Attorney Zackaria, it's my understanding that this is your first appearance in front of the court. Our custom is to invite counsel back to take the greetings of the court, so we look forward to meeting with you.
All rise.
And good morning, you can be seated. If it's still morning, I apologize for the delays this morning. We've been running a bit behind. The matter now before the court is Penobscot 24551, Amarylis Fisher versus, well, it's titled the City of Bangor, but it's actually concerning every other city and town except Bangor this morning. I see counsel are present, and I assume ready to argue. If counsel could identify yourselves by saying your names for the record, please, together with the party you represent.
Yes, Your Honor. Mark Franco for the appellants, Town of Hamden, Town of Vesey, Town of Orono, City of Old Town, and City of Brewer.
Good morning, Your Honor. This is Charles Gilbert speaking. We represent the plaintiff appellee Amarylis Fisher, along with my co-counsel Dan Stevens.
Thank you. And counsel, we are being streamed both by audio and by video. If you're ready to proceed, Attorney Franco, we'd be happy to hear your argument this morning.
Thank you, Your Honor. May it please the court, Chief Justice Stanfield, Justice Lopez, Justice Meade, Justice Connors, Justice Douglas. It's my pleasure to be here to argue on behalf of the appellants in this case. This case arises out of an unfortunate incident that occurred on August 15, 2020, when the appellee, Amarylis Fisher, was struck by a City of Bangor bus while she was visiting Bangor as a tourist, and she was utilizing its pedestrian crosswalk. The only basis for the claim in this case against the defendants is the acts or omissions of the bus driver. The bus driver, it's without dispute that the bus driver was an employee of only the City of Bangor, and that the Maine Tort Claims Act contains no applicable exception to the immunity that it provides to the appellants in this case. We are, this is an appeal from a decision from Justice concerning a motion for summary judgment. In that decision, the Justice, I guess what I would describe as somewhat put the cart before the horse, in that there was no analysis of the immunity issue in the case. If you review the appendix, and specifically my motion for summary judgment, you will see that the first argument in the motion relates to the issue of whether or not there is immunity under the Maine Tort Claims Act under Section 8103. And if you review the the order on the motion for summary judgment, the first issue of analysis in that motion relates to the issue of joint enterprise. And in the order on motion for summary judgment, the court basically determined that there were factual disputes that on the issue of joint enterprise that precluded a discussion or a decision on the motion of on the issue of immunity. I would suggest, consistent with Justice Meade's analysis in the City of Lewiston, the State of Fortier versus City of Lewiston case, that it's a separate analysis. You have to deal with the issue of immunity first, and the issue of whether or not there's an exception to immunity, and only after you deal with that issue and go through that analysis can you get to the issue of negligence or joint and several liability or anything like that. In this case, there was a conflation of the analysis, and I think the justice got stuck on the facts or alleged disputed fact on the issue of joint enterprise, which I would state at the outset, there's nothing in the Maine Tort Claims Act that allows even the inference of a joint enterprise theory under this facts or any other facts.
I see that the green light is on. If the issue of a joint venture or a joint enterprise is important to the resolution of the immunity question, do you agree it's a fact issue on this record?
It is a fact issue.
That there's a dispute of fact as to whether there was a joint enterprise on this record.
Well, that's what the court concluded. I would say that the citations that are cited by the appellee in his brief cite to public documents that do not create an issue of disputed fact. But I can understand why a judge could determined there could be other facts.
And in Bean
relevant.
versus City of Bangor, we made it clear that an interlocutory appeal under the immunity exception will not be entertained if there are underlying fact questions that must be decided in order to determine the immunity issue, right?
Yes, Your Honor. But there are no issues of fact with respect to the issue of the exception, the machinery and
Well,
the
if there's a
automobile
joint
exception.
enterprise or joint venture, isn't there then a fact issue as to the use of the bus?
Not in this case, Your Honor. None whatsoever.
Why?
There's no issue of, the bus was owned, maintained, registered by the city of Bangor.
If the City of Bangor does so as part of a joint enterprise, though, with the other towns or cities, doesn't that at least raise an issue as to whether they are also engaged in ownership, maintenance? and
No, Your
use?
Honor, because as, again, I'll thank Justice Meade for not retiring. Under his analysis in the Fortier case,
We might pay attention to what he wrote before, and even if he does
That was a
retire.
simple plurality decision. It took 5 months to reach.
right, well, and anyways, if the court remembers, the court also talked about in the Fortier case, the fact that you had to deal with the specific event in question and when it occurred in determining whether or not there was a
Right,
factual
can I just ask
dispute.
you this? Can the city of Brewer say, we want all drivers to be, over the age of 25 and have a commercial Class 3 license, and have that happen? Would the city of Brewer have the prerogative to control who's driving the buses that are cruising through Brewer under this?
Or is there at least an issue on that?
No, Your Honor, there is not. There really isn't. The city, none of the. So first of all, the Community Connector program Community Connector is not even a legal entity. It's just sort of a program that is run by the city of Bangor, all facets of it. There are participants in the program, the cities, the towns, and they are representatives, and they go to meetings and things like that, but they have absolutely no decision-making authority whatsoever on how the Community
So
Connector.
Bangor pays no attention to what any of the other towns have to say on any matter?
Again, I think we're getting a little astray on the issue of joint enterprise, and I understand where the court is going.
I guess the question is, you're suggesting that the immunity issue should have been done first.
Yes.
And are you suggesting that it's the Fortier analysis that should be done? In other words, whether the governmental entity exercises actual physical control over the equipment? Is that the question the court should have answered first?
Yes.
And so why is there not a dispute of fact about control if, in fact, these other towns do have some ability to control the use of the equipment?
I don't think it was, I'm not sure if the actual issue was control in the analysis of Fortier.
That's it. That's what the court said. We have to look at whether the governmental entity exercises actual physical control over the equipment.
Yes.
So is there a dispute of fact in this case about whether the towns other than Bangor have the ability to exercise that sort of control? And if so, is the immunity issue sort of not properly before us because of that dispute of fact?
Your Honor, I would respectfully disagree because, again, going back to the issue of what on the specific day in question, okay, that this was not even a community connector bus. It was an intra-city bus that was operated by the city of Bangor outside of the
Well,
community
is there a
connector
difference
program.
between I understand there's a difference in the routes, but is there a difference between the city buses and the interconnecting buses? I mean, is there a difference?
The buses are basically the same. Right.
One day it could be running a city route, one day it could be running a route out to Brewer, right?
That's right.
So to say it's a city bus is a little bit disingenuous, isn't it?
No, because I'm talking about the day of the day of the accident. It was a city bus operating as a city bus, not as a community connector bus on the day of the accident. And going back to the Fortier decision, the issue of use under Section 8104A1 has to be determined at the time of the accident. And I think we need to focus on that. The use at the time of the accident is undisputed, that it was only being used as a City of Bangor bus outside of the Community Connect. There's no dispute, none whatsoever. So we don't really have to go down the road of joint enterprise, dual purpose, control, anything like that. There was no dispute that there was no control over the bus by any of my clients on the day of the accident. It was completely controlled by the City of Bangor. So,
Can I ask you about the insurance coverage
Yes.
question in this case? Your position, I believe, is that the certificates of coverage that were put into the record for each of the towns demonstrate conclusively that there was no waiver of immunity. Is that?
yes, yes, Your Honor.
And you're relying on Doucette for that?
Doucette, it's the same identical certificate in Doucette.
Is
Same
there
thing.
any problem, given that it's your burden, that the actual policies are not in the record?
No, Your Honor. The Doucette didn't have the policies. All we put in, actually, Doucette was my former partner Ed Benjamin's case, but the only thing that was put in the record in that case were the certificates. The policies are 120 pages long and make no reference to limitations of damages anywhere other than the cover page. It's sort of called the declaration page. So the absence of the policies is not even relevant. I know that the justice wanted to see the policies, but point in fact, I filed a motion for summary judgment based on Doucette. And it was good then, it should be good now.
Your view is that issue is not really live, and the only question is whether your clients are in fact immune. There's no waiver, and so we get to the immunity question.
Right, I respectfully disagree with the justice's decision on the insurance. I think, again, he said that they were ambiguous terms within the certificate itself, and then he said, I need to see the entire policy, and I would just respectfully disagree that they're not ambiguous at all. They couldn't be clearer in terms of the $400,000 cap and the fact that...
But you do agree that if we were to find that there was at least an issue of fact as to whether your clients had sufficient control or use to be held liable, that would also mean that there's insurance coverage. In other words, if we found that there's at least an issue of fact at this point for the exception of immunity to apply out of ownership, maintenance, or use of a motor vehicle, then there also means there's coverage, right?
Under the exceptions, there's coverage. There's a cap of $400,000.
Yeah.
I would like to say, I know that I have a yellow light. The elephant in the room, Your Honor, the reason why you're here is because there's an allegation here by the appellees that if the joint enterprise theory holds, that they get to stack the $400,000
I understand
limitation. I know that that's not before you right now, but that's the elephant in the room.
Well, I don't know if it's an elephant. It's perfectly clear that that's why we're
Well, but it's an issue.
I mean, there was a catastrophic injury.
Catastrophic injury, but under the Fortin case, it doesn't matter. There could be 5, there could be 10, there could be 40 defendants in the case, and it's still subject to a $400,000 cap. It's just a limitation. It's $400,000, and that's what the statute says, and it's per occurrence. And there's only one occurrence in this case.
Thank you.
Thank you, Your Honor.
Attorney Gilbert, we'll be happy to hear your argument. I take it you're asking to be able to remain seated.
Yes. Good afternoon now, and may it please the court. These municipal appellants have come before you without a final judgment, asking you to review the decision of the Superior Court denying their motion for reconsideration, which in turn relates to the underlying motion for summary judgment, which the Superior Court also denied. They come before you and claim that this is an exception to the final judgment rule under the death knell doctrine for cases in which immunity is the dispositive issue. We disagree. First of all, this case, as your questions have amply illustrated, is in large part about insurance and insurance coverage. And it's important to remember that under 8116, immunity ends where insurance begins. So if there's any coverage, then there's no immunity. And so I think that's really what Justice Maloney was focusing on, and I think that's the correct focus for this case as we go forward. And so, just for example, as you just were discussing a minute ago with Mr. Franco, the entire policy was not before Justice Maloney, and he considered that important. And one of the reasons is because of the rule in the summary judgment practice realm, which says that in order, the moving party has to demonstrate the absence of a material fact. And one of his two rulings in this case is that the defendants failed in their burden of demonstrating the absence of an issue, genuine issue of material fact. So that in and of itself, on this level, if that's upheld, is the end of this appeal. The court also did not address, nor did the appellants in this case, the issues that are raised in count 3 of our complaint. Under 49 CFR Part 387, federal law, a bus of this nature, more than 15 passengers, traveling in interstate commerce, is required to have $5 million of financial responsibility, not $400,000. The issue of preemption, the issue of whether or not there's interstate commerce, none of that has yet been briefed or argued or presented. So that in and of itself would be enough under the State of Bean and the Wilcox versus South Portland cases to send this case back. The other area that we get into is the area, obviously, of the joint venture. First of all, there's no question that this tragic and catastrophic accident occurred in the use of a motor vehicle. What Mr. Franco's argument is, it's not ours. And that ties right into the issue of joint venture. So it seems to me that what we should be asking are the following. First of all, does Maine law recognize joint ventures? And the answer to that is yes, going back at least as far as 1931. And that's the Trumfelder case.
Can I see the green light is on. Is it your position with regard to the insurance coverage? I mean, we've accepted certificates of coverage before in our courts, right?
Yes.
Okay. Is it your position that if these towns could be held liable on this record under Section 8104A1, then there's coverage? In other words, sufficient so that we don't get to there may be a question of how much coverage,
right?
But there's coverage, and so it's no longer an issue before us right now of immunity.
Well, but again,
and immunity is the only hook that gets you up here for a interlocutory appeal.
Well, the way I read the Bean line of cases is that it's not just a question of coverage, but the sub-question that you just mentioned about how much coverage. Because under the facts of this case and under the requirements of federal law, if it's applicable, then their liability could exceed the $400,000.
But that's not an immunity question, is my point, is it?
Well, it's not an immunity question.
And that's, for our purposes here today, on an interlocutory appeal, the only thing we deal with on an interlocutory appeal would be immunity. And as we've said in Bean, if it's a fact question as to immunity, we don't take the appeal.
Yes, I agree. Okay. So the second thing on joint ventures, after does Maine law recognize it, which the answer is clearly yes. And question number 2 would be, can municipal governments enter into joint ventures? And the answer to that is also yes, and that we cite for authority the ALR annotation that's in the brief. And I note, I hardly ever go to ALR first anymore, it's so old, but that ALR annotation has been around a long time, establishes and collects cases that indicate that, of course, municipal governments can enter into joint ventures.
Just address the Fortier case where we talked about the importance of control. Is your argument, do I understand it correctly, that whether the towns here had sufficient control over the vehicle turns on this sort of joint venture question?
Our focus is different than the appellants. Mr. Franco wants you to focus on that one bus on that one day at that particular moment. We ask you to focus and believe the correct legal area of focus is system-wide. The whole operation and setup of the system on a corporate level. And actually, it isn't a corporation. It's a non-incorporated joint venture. And so if you look at that and you look at the materials that were reviewed by the trial court to determine, and remember the second ruling that the judge made below was after ruling that they had failed to meet their burden, he went on to say, and by the way, the plaintiff met her burden of showing there was a triable issue of joint venture, which incorporates that issue of control.
So we're looking at that issue, the sort of corporate structure, to determine whether the use exception to immunity applies or not at this juncture? Is that how you see it?
Well,
Is it a corporate
the big
structure?
picture in this case, and the overarching goal that all of these municipalities have together is, number one, to have a regional bus system that serves not just Bangor, but serves all of these towns around Bangor. And number two, and this is what I say the elephant in the room is federal money. If you look at the summary judgment papers, you will see that this whole system is funded, or not entirely, but a very large percentage of this community connector system is funded by federal dollars. And to have those federal dollars, you have to have these other towns in the picture. They cannot, Bangor could not have done this alone. There would be no community connector if it was just Bangor.
But can you explain to me how that helps us answer the only question before us now, which is whether there's immunity for these particular towns? It goes to the issue of waiver through coverage above the Act's limits? Is that?
I think it's important to look at the issue of what the Tort Claims Act does and what it does not do. The Tort Claims Act never changed the common law of responding at superior imputed liability, nor the law of joint ventures. None of that, those tort doctrines exist independently and continue to exist, notwithstanding the Tort Claims Act, and they were not overruled or abolished by the Tort Claims Act. So if you apply longstanding tort doctrine to this case, you come up with the answer that yes, a joint venture can be held liable. And that Texas case, pardon me, the Texas case that we cite in our brief is actually quite illustrative of that point, because in that case, the jury found that the Texas Department of Transportation was not negligent in its role in operating the HOV lane where the fatal accident had occurred, but nevertheless, the Department of Transportation was held legally liable as a joint venture. And so that's how joint venture law works.
Just, you referred to the federal aspect. That concerns interstate commerce, does it not?
Yes.
You and I are both familiar with Penobscot County and the municipalities we're talking about here. It's a pretty large area, but it's not by any stroke of the imagination.
First of all, I think there's a lot of law out there on what is and is not interstate commerce, and the scope of interstate commerce can reach quite deeply, but we haven't briefed or argued that yet, and it hasn't been presented to or decided by the Superior Court. Number two is that we allege in the complaint, in particular, that these bus routes are part of an interstate commerce system because students at the University of Maine use that bus system to get down to Bangor to take the Concord Trailways or to get on an airplane. The bus system stops at the Bangor airport, and the only place you can go if you get on a plane in the Bangor airport is somewhere out of state. And it also stops at Hudson College and other places where there will be people that are in interstate commerce. And so there is a theory, but it hasn't been presented yet or decided, that says that that type of bus system can be part of interstate commerce. So,
as a matter of fact, this may be outside the record, but if Brewer or one of the other communities wanted to discipline a driver, we'll say, do they have that prerogative under any of the written documentation that covers this agreement?
well, that's the problem. There's very little written documentation. But the answer is that we produced evidence that the Superior Court considered that at least the towns had say-so regarding budgeting, the towns had say-so regarding placement, whether they got into the nitty-gritty of whether driver A was going to be disciplined or not, I don't know.
It's really a financial arrangement, isn't it? I mean, Bangor runs a system, and for a certain price, they'll expand that out to the hinterlands. And it's a financial agreement, but
No,
still
well,
Bangor's
in part, but not totally, because again, the way that the federal law is set up, those other towns have to have a seat at the table in order for that to work. Bangor can't just say, okay, you pay us $100,000 and we'll run your bus system for you. That isn't how it works, and that isn't how the law works. So, I guess I would like to just point out that, you know, the Superior Court Justice was already quite familiar with this case by reason of having heard and decided the motion for summary judgment that the city of Bangor had brought, which he denied. And so in this case, he carefully examined the motion papers and applied the rules, the existing rules regarding summary judgment practice, regarding the burden of showing the absence of material fact, and drawing all inferences in favor of the non-moving party. And he came to the conclusion that this accident arose out of the use of a motor vehicle, and that applying uncontroversial joint venture law to the facts of this case, there was a triable issue of whether or not there was a joint venture under which these defendants as joint venturers could be held liable. We think that is correct, and so therefore the correct result from our point of view is to send this matter back to the Superior Court to allow the plaintiff her day in court. I mean, she came to Bangor, a retired civil servant from California came to Bangor. She was a world traveler, been all over the world, and she came to Bangor to see Stephen King's house. That's something that is a thing in Bangor. Maybe not everybody does it, but we have visitors who come to see Stephen King's house. She left 5 months later, spending 4 of those months in the hospital and a month in a rehab facility, about $1 million worth of medical bills, and her leg was amputated at the hip. So now, instead of being a world traveler, she's confined to a wheelchair for the rest of her life. So I understand, having been to this court before, that your focus is on the legal issues, but there is a factual context here, and I submit that the Superior Court correctly applied the legal rules, and that the doctrine of joint venture is not superseded by the Maine Tort Claims Act. If there's a joint venture, then a municipality who is a joint venturer is subject to liability to the same degree as any other joint venture would be. And that's got nothing to do with immunity. The substantive immunity applies separately. But this arose out of an auto accident and arose out of the use of a motor vehicle. So there's nothing, what I think Mr. Franco is asking you to do is read in something into the statute that's not there, just as the town of Wells tried to do in the Conway case, which is the high-speed case, where the word collision did not say it had to be a collision between the principal vehicle and the plaintiff's vehicle. In that case, it was the car being chased that collided with the plaintiff's vehicle. And the court said, we're not going to read something into the statute that isn't there, and that's what I think the crux of their argument is. Thank you.
Attorney Franco.
Thank you. Thank you, Your Honor. Going back to why we're here.
Can I I want to make sure I understand your argument. Are you saying that in the abstract, if it was a community connection bus driver, if there was a joint venture where all the participants in the enterprise had a say about the driver, that could mean that they all were using it but under the facts of this case, that's not the type of joint enterprise here, and that's not what was being used at the time? Or are you saying that no participant in a joint venture town, as a matter of law, is liable under the statute, except if the bus happens, except for the one where the bus is within that town, owned by that town?
I'm actually kind of saying both, Your Honor, and that is, there's nothing in the statute, and I understand and appreciate Attorney Gilbert's argument that the issue of joint venture is still alive in the state of Maine, but it absolutely does not apply in the context of the Maine Tort Claims Act.
So there could be no circumstance in which towns get together, jointly hire one bus with one driver, and the accident happens in one town. Wouldn't they all be liable?
Again, I go back to the statute. If the statute doesn't say that, then I have a hard time
So who's
applying
using it? Which town is using it if they all chipped in, bought one bus, and the driver is being paid by them all equally?
Then that would be probably a question of fact in determining which town should be responsible.
But it would only be one?
I don't know the answer to that, Your Honor, but I would go back to your earlier question, is that even if that argument can be made and that joint venture could be applied, it can't be applied under these facts.
So it's a fact issue?
No, Your Honor, it isn't. The issue, the problem is that the justice never even addressed the issue of immunity in his order.
Well, but if immunity, if the town could be liable, the outlying towns could be liable as joint venturers under 8104A1, then the immunity issue is a fact issue, isn't it?
He never even talked about immunity in his decision, and he never even talked about the use exception to immunity. He never even analyzed, as he was required to do, the 40-year analysis. I'm asking you to employ the 40-year analysis and issue a decision on whether or not, using the 40-year analysis, whether or not immunity applies or doesn't. You may, but if you jump beyond the issue, if you rule that there's an issue of fact on use, then you're already jumping to the issue of joint venture and joint enterprise, if you will, and you're sort of skipping the initial issue of immunity. And I think you need to go through the steps, as I keep going back to Justice Meade, articulated in 40-year. If you go through those steps.
Thank you, counsel.
Thank you.
As is our usual practice, we will be taking the matter under advisement. We'll issue a written decision in due course. I'm kind of curious who all these young people are in the back of the room and why they've been watching every argument.
We're students at Maine Law.
Okay. Well, welcome. Hopefully it was at least somewhat entertaining this morning. So I noticed that you were all here through more than one argument. That's why I wondered. Okay, thank you, counsel. And with that, we'll be in recess for the morning.
All rise.